First of all, there is no need for the court to satisfy itself that the measures of which the applicant complains actually constitute racial discrimination within the meaning of Article 1, Paragraph 1 of the Convention. Secondly, the facts should be considered as such by assuming that they are established. At this stage, it is not a matter of assessing the evidence that has been produced or to ask for more evidence. Thus, it is totally unnecessary at this stage to delve into linguistic exegesis or to assess the significance of certain statements, as Mr. Wordsworth did yesterday. It is just as incorrect to contend that Armenia allegedly did not provide sufficient evidence at this stage, because it is impossible to reach this conclusion without examining that evidence, and that can only be done at the merit stage. Thus, declaring at this stage what can or cannot be admissible as evidence produced by Armenia is inappropriate at this stage. And as my colleagues will demonstrate, there is no shortage of evidence. Azerbaijan contends that it is unlikely that the possible different treatment complained of by Armenia, and that is the subject matter of the second preliminary objection, is based on race, color, descent, or national or ethnic origin. It is not contested, however, that ethnic Armenians represent a protected group under the Convention. Furthermore, it is clear that among the specific obligations in relation to the treatment of individuals on the basis of race, color, descent, or national or ethnic origin, there is notably an obligation in Article 5 of the Convention to ensure, without any discrimination that is prohibited, the enjoyment of, and I quote, the right to security of person and protection by the state against violence or bodily harm, whether inflicted by government officials or by any individual group or institution. There is also an obligation to ensure non-discriminatory enjoyment of the right, and I quote, the right to equal treatment before the tribunals and all other organs administering justice. As my colleagues will demonstrate, the violations that Armenia is complaining of and that Azerbaijan would like to exclude from substantive discussion are related to the treatment inflicted by Azerbaijan on ethnic Armenians and Armenian nationals in breach of these obligations and others in the Convention, including when the victims have taken part in the hostilities. By applying the same reasoning as the court's reasoning in its 8th of November 2019 judgment in Ukraine versus Russian Federation, we can conclude that the measures complained of by Armenia are capable of having an adverse effect on the enjoyment of certain rights protected under CERD, and insofar as they fall within the provisions of the Convention. Yet, Azerbaijan argues that because the facts complained of by Armenia occurred in circumstances of armed conflict, this would necessarily imply that the reason for this difference in treatment could not have been that the victims were ethnic Armenians, in which case these facts would not fall within the scope of the Convention. According to Azerbaijan, if the violations complained of occurred during the active phase of an armed conflict, there is a kind of a reversal of evidence, so to speak, because it now needs to be demonstrated that these violations cannot be explained by the circumstances, and therefore something more needs to be done or to be proved. Azerbaijan's position is wrong for three reasons. First of all, this position is based on the premise that because IHL applies in times of armed conflict, breaches of the Convention could only be additional or even secondary compared to breaches of the law of armed conflict. This notion is incorrect because both these sets of rules apply simultaneously when their respective conditions of application are encountered or are met. Contrary to what was argued yesterday, Armenia is not making claims based on international humanitarian law, to which it has added claims falling under the Convention. Furthermore, Armenia's claims under the Convention do not replace claims that it should have made under international humanitarian law instead, as Azerbaijan implies. Furthermore, let me recall that at this stage, it is only necessary to examine if these claims that are made by Armenia violate that are likely to breach the obligation of the Convention in such a way as to fall under its scope as defined by Article 1. The purpose here is not to reach a definitive conclusion on the existence or not of racial discrimination. And indeed, even if, quod non, the differences in treatment complained of could also be due to reasons not provided for by the Convention, they would still not fall outside its scope. Indeed, nothing in Article 1, Paragraph 1 of the Convention indicates that for discrimination to be based on a prohibited ground, it is necessary for this ground to be the only ground for the motivation or explanation of that discrimination. Such a conception would considerably narrow the scope of the Convention and would thus contradict its object and purpose, which is to speedily eliminate racial discrimination in all its forms and manifestations. Indeed, as the Court has held, and the parties have agreed, the Convention does prohibit no other reason for discrimination apart from race, color, descent, or national or ethnic origin. But we are not adding an additional ground for discrimination on the Convention if we consider that grounds that it does not provide for can coexist for the same different treatment with grounds that the Convention prohibits. Further, very often, in fact, a discriminatory measure based on a ground that is prohibited will follow other grounds that are not covered by the Convention, without the initial ground falling outside the scope of the Convention. The committee says precisely that in its General Recommendation number 32 by underscoring that double or multiple discriminatory situations can exist. Armenia is reading of the General Recommendation is not that it extends the grounds for discrimination prohibited under the Convention. And the Court's most recent jurisprudence confirms this point. In its judgment of 31st of January last, the Court recalled that any measure whose purpose is a differentiation of treatment based on a prohibited ground under Article 1, Paragraph 1, constitutes an act of racial discrimination under the Convention. Therefore, in substance, the Court has not required that differentiation in treatment should be based exclusively on a prohibited ground. In this case, it is undeniable that the purpose of differentiation of treatment complained of is perfectly likely not to be unrelated to a prohibited ground under the Convention. Finally, and precisely on this very point, Azerbaijan is mistaken in arguing that an additional specific burden of proof falls on Armenia and that it is not met, because in this case it is mere collateral or secondary effects on persons who are distinguished by one of the prohibited grounds, and that it is well established that such effects do not in and of themselves constitute racial discrimination within the meaning of the Convention. Azerbaijan is mistaken because this question only arises in the case of indirect discrimination, that is to say, discrimination that is prohibited by the Convention depending on its effects. However, Armenia claims that are the subject matter of its preliminary objection fall under direct discrimination. The facts presented by Armenia, facts that the Court at this stage should consider as established, are perfectly likely to fall within the ambit of the Convention under direct discrimination, that is to say, discrimination resulting from a measure that seeks to make a differentiation in treatment based on a prohibited ground whose purpose is to deprive victims of equal enjoyment of their fundamental human rights. Members of the Court, the criteria for the Court's jurisdiction ratione materiae are clearly and perfectly met. Mr. President, I would like to thank you for your attention. I'd like to thank the Court for its attention, and I would like you to invite Professor Sean Murphy to take the floor. Thank you very much.